Hi, everybody. I hope you're having a good morning so far. It's been a little bit since I've been online. I got a little sick, but I think I'm finally starting to recover. So, um, getting back into studying torts. If you're just joining me for the first time, I graduated from law school, and I'm studying for the bar currently. Um, and it's very boring to do by myself, so I decided to stream. And if people want to follow along or learn, feel free to. And obviously, like, none of this is legal advice. And I'm just going to jump straight into what I'm studying because this is like 5 hours of studying a day. And I'm also working part-time at my firm that I'll start at in the fall. So bar studying, working, I'm just going to get right to it. So what we're going over today are torts. And again, these are like personal injuries that you can sue for. So things like assault, fraud, which is what we're going to go over first. So right now, what I'm doing for bar prep, I am going over my flashcards for this subject. I've already read the outline and and watched all the lectures. And I took this class my first year of law school, so this is like 85% refreshing my memory. All right, so this flashcard is asking me what are the elements of intentional misrepresentation? And intentional misrepresentation is basically like fraud. And I cannot spell representation. Okay, so some of this I'm doing from memory. So from what I remember, the elements of intentional misrepresentation is you had to have made a misrepresentation of a material fact or failed to disclose a material fact when you should have. Um, you had to have known that it was false, or you were acting with reckless disregard. Um, the false statement had to have been meant to encourage the person to rely on the information. The person had to rely on the information, and it had to have hurt them. Okay. Misrep. Why can't I spell misrepresentation? Let me check. Yes. Made false statements or failed to disclose knowingly or with reckless disregard. Yes, good job. Okay, intended to have plaintiff rely on information. Plaintiff did rely on the information, and the reliance caused harm. Nice. Oh, hey, Olaf. Oh my gosh, it's so good to see you. Things have been so crazy, Olaf. Are you being kept busy today? Or just lately, not even just today? Oh, so good to see you too. Um, okay, what are the elements for, okay, yeah, I guess I might as well do that one. Okay, intentional interference with the contract. So that's like improper like business competition, basically. So if I remember that, there has to be a contract. Someone had to have known about the contract. They must have tried to cause the other person to breach the contract, and it must have hurt the plaintiff, I think. Yes. Intentional interference, the contract. Contract has to exist. The defendant has to know about the contract. Defendant intentionally interferes to cause breach in contract, and breach causes damages to plaintiff. Okay. Hi, Maury. Oh, so good to have you both here. Watching while I wait for a washer delivery. Waiting for deliveries. I always feel like a little puppy dog when I'm waiting for deliveries. Like I'm usually just like waiting by the window, just waiting. I don't know if a washer delivery is quite that exciting. I actually kind of think it might be. All right. So all right, when can a child be held responsible for something? Okay. Well, child or mentally incompetent person. Um, Shoot. I mean, I think they have to know the nature of their act and be aware of the consequences. That doesn't sound quite right. Oh, all right. That doesn't really help. If they have the required mental state, intentional, reckless. Okay, so I guess you don't really get out of much. Hmm. Oh, okay. A child, I see what this is saying. A child or mentally incompetent person can be held liable for intentional acts if they have the required mental state. That makes sense. So, like a child or mentally incompetent person, it wouldn't make sense to hold them liable if they were like negligent, because children are literally like always negligent. But if they do something intentional, then it's more likely they could be held liable. Got it. Got it. Got it. How to sue children 101. There's this case that we read in law school. I still remember it, where a kid was playing like a prank on like just I don't know, a woman, and they pulled the chair out from underneath her when she went to go sit down, and she ended up like really injuring herself. And there's just a lot of fight over like whether the kid actually knew how bad the injuries could be or what they were doing. And I just always thought that was so interesting. So it was really like a 4-year-old. Um, and I mean, the parents ended up having to pay. But yeah, actually, that might not be true. I might have to go back and see that case. I'm gonna have to look that back up. That's the one thing with law school. Some cases just you really cannot hold all the cases together. What is the doctrine of? Well, now I'm curious. So now I have to look that up. I can't leave myself for you guys hanging. Court case, polls, chair, law school. Yes, this is the case. Um, well, what happened? Yes, they did hold the 5-year-old. Oh, so the first time they did not hold the kid liable because he didn't know the lady was going to break her hip. Then they went to appeals, and the court sent it back down, and then they found for the plaintiff. So ultimately, the kid was found liable. Sue kids are assholes. Sue all the kids. I know. I was a kindergarten teacher, and I still won't forget the day that like my sweetest student came up to me, and I thought she's like, Miss A, like she's like, can I ask you a question? And I was like, yeah, and she was like, did you brush your hair today? And I was like, yes, and she was just like, it doesn't look like it, and like I still have that stuck in my head. Kids are definitely can be assholes. Okay, what is my next one? Okay, what is transferred intent? So if you intend to like harm somebody or do something, but instead you actually harm someone else, you're still responsible. So even if you like miss your target and you still end up hurting someone else, you are held liable. Yes. All right. Transferred intent. So intend to commit an act. Yeah, an act against one person, still liable if it happens to a different person. Okay. Imagine being involved in an embarrassing case that ended up forever being used as an example in law schools. I think about that all the time. Because, yeah, I think about that a lot. Um, because there's definitely some very embarrassing and strange cases. And like people remember them for years. Like at the firm that I work at, like all of some of the partners are like 85 years old, and like we can still tell jokes about like the same cases, and like that's that person's legacy. Like I remember one contract case was about someone getting like the wrong size chickens from Germany, and they just like lost their shit because of it. And that case is one that's just like burned into my mind, and that's that person's legacy. To which three doctrines does transferred intent apply? I believe that is assault. Well, I don't think that's what they're asking. Yes, it is. Yeah, assault, battery, and false imprisonment. So if you mean to false imprison one person, but you accidentally false imprison another, you are going to still be liable for that. When determining whether contact is offensive for battery, what are the objective and subjective tests? Well, okay. So battery, I'm going to put the elements of battery again, which is you have to intend contact, you have to make contact, contact has to be offensive, and it has to cause harm. Okay. So when is it offensive? How do you decide when things are offensive? There's two ways. Generally, the objective test, which, I mean, how objective is this? Offensive, I think it's to a person with regular sensibilities. Yeah. With reasonable or ordinary sensibilities. And that doesn't sound super objective to me. I still always think that, like, I don't know, what I think is a person of ordinary sensibilities is going to definitely be different than like what a Supreme Court justice thinks, probably. So I don't know. But that's what they say is objective. Anytime they use the word reasonable, that's considered objective. Subjective test, that's when you you know that the person is extra sensitive, and you do it like because of their sensitivity, I think. Yes. Knows the contact would be especially offensive to that person's personal dignity and makes contact with purpose of offending. Let me see what a good example of that is. I don't really know. Substantive tests better. I'll look that up later. Okay. All unreasonable people believe they are reasonable. That is very, very true. All unreasonable people do believe that. What qualifies as contact with the plaintiff's person? It just means their person or anything attached to their person. So their clothing, a pet on a leash, the bicycle ridden by the plaintiff. Okay, yeah. To person, or I'm just gonna say like an extension person. Okay, does the plaintiff have to be aware of what is oh wow, you just made me I feel like these bullet points describe my sense of humor. That's hilarious. That means you're doing really, really great work. Go lot. That's all that means. Must the plaintiff be aware of what's happening for an act to constitute assault or battery? They have to be aware for assault, but they do not have to be aware for battery, if I remember. Yes. Awareness required for assault, not for battery. Okay. What are two ways in which assault differs from battery? Well, one, you don't have to be aware. I just said that. Two, you don't have to actually even touch the person. Yes. Okay, I already know that. I don't need to write that down. Well, I might as well. Awareness. Well, let me just put this. No contact required for assault. Because assault is just being in fear of something happening to you. Battery is when the thing actually happens to you. What is the imminence requirement for assault? So for it to be assault, you have to be in like reasonable fear of imminent danger. Or maybe like harm, maybe not danger. Perhaps danger. Or bodily contact. Are words enough to establish a case of assault? This is a great question for a lot of you people on YouTube. No. Yes? No. Oh, bad. This is bad. Okay, I knew it was no. I knew it was no. No one judge me. I knew the answer was no. But if you have words and something else, that can be enough. Yes. And it's not assault if they say they're going to do it later. It has to be imminent. So if someone says, I'm going to come back here in 2 hours and hurt you, that is not assault. Reasonable fear like JLR. Oh my gosh. Then and when these YouTubers pick up on those legal terms, they just like use them constantly. And I mean, I can't even. I can't even. Does someone make a song? Does someone make a song, a reasonable fear song about him? Or was that hmm. Was that you? Maybe that was you. Maybe that was Olaf. Okay. Um, let's see. What is considered extreme and outrageous for the purposes? Okay, it was you, Olaf. I told you I love all of your songs. What is conduct is considered extreme and outrageous for the purposes of intentional infliction of distress? So, intentional infliction of emotional distress, which is also, you'll hear lawyers call it IIED. Um, well, I think it has to exceed the limits of human decency and be sufficiently unusual. And like not done in civilized society. Those are like the three things. Yeah. But I don't really know. Yeah. Extreme must be extreme and outrageous behavior that exceeds limits, human decency, and civilized society. I think, oh my gosh, I can't not spell today. Well, probably not like making someone look like a cow on AI. That's probably not extreme and outrageous. I think that's actually something that happens in civilized society. Okay. When can a defendant be liable to a third party for IIED? I think it's if they're a family member or who sees the conduct. Yes. Can be liable to third party if they are a family member, witnessed the conduct, or were the target of the conduct. So like really bad examples of these are like parents divorcing and then one parent doing things to the kid to like harm the other parent to like inflict emotional distress on them. That's like fortunately a super common one that I've read about in torts. That's why this torts and criminal law were my least favorite classes because they were the most depressing. Um, if the designer purpose was to cause severe distress, yeah, okay. What does it mean to be confined within a limited area for false imprisonment? Um, um, there has to be no safe exit. Um, I don't think that, or I'm not going to say this right. This is a good thing I'm doing these torts flashcards. I did know this. Okay, so false imprisonment. A confined area equals somewhere where movement in all directions is constrained. Can be a large area, just no exit, no safe exits that person is aware. Okay. Oh, you are going to be a better lawyer than all of Warren Mathias's brothers combined. That's hilarious. I do wonder how Pace Conte Sauce is doing. We've heard lots about all his all the other people at his firm, but I do wonder how Pace is doing. I hope he's doing well. In what ways may a plaintiff be confined resulting in false imprisonment? Physical force, physical barrier, or threat, or asserting legal authority. Can be confined by force, threat of force, barriers, duress, or legal or asserting authority. Okay, what is the merchant's privilege? This is when a shopkeeper can false imprison you, but they're not really false imprisoning you. The shopkeeper's privilege or the merchant's privilege allows you to detain someone on premises if you have a reasonable belief that they may have stolen something, and you can only keep them for like a reasonable time to investigate, and it has to be done in a reasonable manner. Yeah, nice. Cool. It has to be done on premises. Okay. Owner can detain reasonable means if they have reasonable belief that person has stolen, can only keep them for a reasonable amount of time to investigate. Okay. How is express consent established? Sorry, I'm reading this. Plaintiff, if they're willing? Okay. Well, all right, I'm not even going to write that down. That's a stupid flashcard. When is the use of deadly force justified in self-defense? I think only when you reasonably believe it's necessary to prevent like deathly force on you or someone else. Or the R word. I forgot about that one. Well, that's kind of nice. You can use deadly force for R. Good to know. Okay. Okay, so you have to have a reasonable belief of intentional force that would put in peril of death or rape. And only way to prevent is by using deadly force. And that's to defend you or someone else. Last clear chance doctrine is a negligence. That occurs when the plaintiff says that the defendant had the last chance to avoid injuring the plaintiff. Okay. Last chance doctrine of negligence. Plaintiff reduces their liability, proving that the defendant had the last chance to avoid. So an example of this is like, let's say somebody I don't know, throws their scooter in the middle of a road, but it's a closed road and a car goes down that road anyway and like hits the scooter. The person might be able to argue like, yeah, it was my fault for leaving like the um scooter in the road, but like this car shouldn't have even been going down the road in the first place. If they hadn't done their negligence, then the scooter would have been fine. Now, I'm pretty sure in that situation, the car might get damaged more, but I don't know. Or no, I actually have no idea. Okay, anyway, I'm getting a little hyper because I am so ready to be done with this subject. And I'm on flashcard 70 of 82. And I'm just very tired of this subject. When is the use of force in defending others justified? Okay, I know that. You can use force in defending others when you believe it's the only way to prevent like unlawful force against them. When can you use force to defend property? Basically, like never. That's not true at all. Oh, you can use force if it's not going to cause death or serious bodily injury. Okay. Using force to defend property. You can do that when you reasonably believe force is the only way to prevent the intrusion. You ask the person to retreat and they don't. The force used is proportional to the value of the property at risk, and the force won't cause death or serious bodily injury. Right. Okay, when can someone use deadly force to defend property? Never. That's the one. That's never. Can never use deadly force to defend property. So no setting up like crazy lethal bear traps or anything on your property. There's been cases where people have like set up like booby traps where like you step on something and the gun goes off. Yeah, you can't do that. So if someone tries to steal your stuff, you can poke them in the eye. Yes, as long as whatever they're trying to steal is equal to the value of an eye, I guess. And that is kind of interesting that the force you use has to be proportional to the value. Like, I wonder how many dollars like equal how much force, you know? Like how many dollars, like how much does it be like to punch someone? How much value do you have to be protecting? I wonder. Like if someone was trying to steal like my AirPods, those are pretty important to me. If someone was trying to steal my notebook with all my law school notes, that might be like a reasonable force situation for me, I think. Okay, what level of force can be used when you're taking back your own property? I'm pretty sure you can't do that. I'm pretty sure you're supposed to leave that to the police. Yes. Um, No force to recapture property unless it is prompt and reasonably non-deadly. This reminds me of when I was in college, I went downtown for like St. Patty's Day, and a 12-year-old stole my friend's phone from her pocket. Like he just reached in her pocket and grabbed her phone. And like we were all just so stunned. And he just stood there staring at her. So she reached back in his pocket and grabbed it back. And then we just walked away. And like his friends were making fun of him. And I mean, I don't love that kids are going around stealing. I actually really hate that memory. But that's a good memory of like when reasonable, non-deadly force was used to recapture property. Yeah, Olaf, I need to know, what is the monetary value of a punch to the face? Like, I don't know, diamond ring? A farm? I don't know. Use of force by parents in disciplining child. I mean, reasonable. Yeah, it doesn't mean anything. I'm pretty sure it's like reasonable to discipline, educate, or like control. Yeah. Educate, control, promote welfare of child. And who knows what's reasonable, but whatever. I've talked to some teachers who taught in the South, and like in their classrooms, like in their schools, people were still like spanking kids, and it was almost like if you didn't spank kids, you weren't respected as a teacher. That would be so hard. I mean, none of my friends like did it, but I just can't even imagine. Ooh, when can you make a citizen's arrest? I love citizen's arrests. Um, if they have reasonable grounds that they saw a felony committed and that that person was the one who committed the felony. That one seems dangerous because I'm pretty sure, like, even off the top of my head, I don't really, well, maybe I don't know, maybe true crime people know felonies off the top of their head. I don't think I know felonies off the top of my head right now, but, um, okay, when, um, yeah, okay, when, see a felony, well, it's actually reasonably believe felony occurred, and that person was the one who committed the felony. And I'm pretty sure if I remember right, even if you make a mistake, it's okay, as long as it was like a reasonable mistake. Again, who knows what that means? What is a public nuisance? I can think of a few public nuisances. Okay, public nuisance. That is when something is interfering with the right that belongs to the public. And usually, if I remember right, the government brings those actions, but a private person can bring them if they suffer a different type of harm than everybody else. So, for example, if a factory is like emitting a bunch of pollutants that only hurts chickens, and um, there's only one person who has a chicken farm in the area, that's a public nuisance. But the plaintiff could bring a private action because it affects them uniquely. Yeah, private person can bring claim for interference of, usually it's like enjoyment of land, when they suffer a harm that is different than public. Oh, Olaf, I got spanked by the principal in elementary school. I'm 31. It feels weird. That's even a thing they did looking back on it now. Wow. Did you grow up in the South, Olaf? Um, that's crazy. I'm in my 30s too, but I never had that. But I don't know. That makes me feel so weird to think about. That is weird. What is a good Samaritan statute? If you are just trying to like render aid, I think I'm just tired because I'm like not finishing my sentences. So let me just read what the flashcard says. Um, Doctor, oh, it's only for medical professionals. I how did I know that? Okay. Law that protects medical professionals when giving emergency care. Saves them from liability for ordinary negligence, but not gross negligence, which is just like worse negligence. You did, Olaf? Yeah, that's because yeah, I had a lot of teachers, um, friends all across the country when I was teaching, and yeah, the ones in the South were the ones talking about that. That's crazy. Yeah, Mari, isn't that crazy? What effect does evidence of custom have on the standard of care? I feel like I've already answered that. I'm not going to do that. Okay, when is a landlord responsible for negligence? Landlord liability for negligence. Well, they are responsible for common things that take place in the common areas, um, hidden dangers, things they said they would repair, and things they have a duty to repair. Let's see. Yeah, they would repair. Um, oh, hazard caused by negligent repair and areas leased for public use. Okay, so landlord is liable for negligence that occurs as a result of a danger in common areas, from hidden dangers, harm that comes from um, not repairing something they agreed to repair, negligently repairing something, or in an area that they've leased for public use. Okay. Yay, I am on 79 of 82. Most important thing a plaintiff must prove to be awarded damages in a negligence action. Harm? Causation? Harm. Yes. Um, okay, I don't need to write that down. When is the owner of a wild animal strictly liable for harm done by the animal? Um, okay. So, liable, strictly liable for harm by a wild animal. I'm pretty sure it's regardless of whatever precautions you take. You regardless if the harm here this. So even if you took precautions, if the harm was caused by like a known trait of the animal, or propensity, you are automatically liable. Also liable for harm, I think it's if the person reacts to the animal and like causes the animal to freak out, you're responsible for that too. Caused by someone's reaction to the wild animal. I'm sure Tiger King probably knows this or has heard this before. Yes. Got it. Doctors, pharmacists aren't held liable for side effects of medicine. No, manufacturers of medicine are not held liable for let me yes. Sorry guys, I'm definitely like stopping and starting. So props if you're sticking with me. Medical. Okay. Manufacturers have a duty to inform the doctor or pharmacist of issues with the drug or device, and the professional is supposed to tell the patient. Yay, one more. How does product misuse affect the recovery damages? If you misuse a product, I'm pretty sure you can't, yeah, recover. Yeah. If you misuse or modify product in a in a way that is not reasonably foreseeable, then manufacturer usually not liable for defect. Yay! All done with torts. Oh, that stunk. That's one of my least favorite classes. All right, thanks guys so much, guys, for sticking with me. What is my next? I'm not sure what my next subject will be. I'll probably be back on a little bit later. I'm gonna go take a break now and do some multiple choice questions. Oh, Olap, let me read what you're saying because I actually want to know about this. It was weird, like your teacher would send you to his office and he'd shut the door and everything so it'd be private, no one would see, which is appropriate now that I think about it. Yeah. Like he didn't do anything appropriate at all. I'm sure he wasn't thinking about that way at all. But if he had been that type, that could have been a horrible situation. Yeah, that's just so crazy. Wow, Olap. I mean, it sounds like you're fine now, but that sounds crazy. I would be scared if I was a kid. Oh, you save big money at Menards. I need to get some sound bites too. I just need to copy all of Jolene's sound bites probably and just put them over here. Thanks guys for hanging out with me. Like I said, I'll probably be back on later, but I'm sure I'll see you in someone's chat sometime. Thanks guys. Bye.